Hello and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, if you or someone close to are navigating life across borders, whether splitting time between the United States and Canada or planning relocations, and you're wondering how to make your estate plan flexible and tax efficient in 2026, stay tuned. This episode was made just for you. Our topic, the 3 questions cross-border families should ask about structuring their estate plan for mobility in 2026. Thank you for taking time to check us out. And if you enjoy this episode of the 3 Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. Welcome to the podcast. With global mobility on the rise, driven by remote work, family ties, and economic shifts, more high net worth families are living across borders, like between Canada and the United States, for example. But this brings challenges, differing tax regimes, such as Canada's deemed disposition rules versus the U.S. estate taxes, potential law changes, and the desire for estate plans that adapt to relocations without costly overhauls. Joining us are 2 returning experts. From Brenham, Texas, Marlon Schultz, a tax estate planning attorney who is also licensed in the state of California. With her firm, Brenham Estate Plans, Marlon specializes in helping clients navigate complex relocations, estate strategies, and asset protections, drawing on her dual state expertise to ensure seamless transitions for high net worth families. And from Calgary, Alberta, one of the places I used to live, actually, just outside of Calgary in Banff, is Craig Privette. He is the founder of The Last Word, a Canadian estate planning law firm that is dedicated to helping clients craft comprehensive wills and estate plans that reflect their unique wishes and minimize family conflicts. Today, we're bringing them together to explore the 3 questions cross-border families should ask about structuring their estate plan for mobility in 2026. Marlon and Craig, welcome back to the podcast. Great to see both of you here.
Thanks for having me, Wayne.
It's going to be fun. Okay, so guys, we got lots to cover. And we have these, I want to go through these questions, but beforehand, I wanted to actually have a conversation and talk about why this topic is so timely in 2026. Now, both of you know and would agree, I think, poorly structured estate plans can create as much havoc as no estate plan. They can lead to double taxation, probate delays, or asset vulnerability. So, from both of you, from your cross jurisdiction experience, Craig, with you in Alberta and British Columbia, Marlon, with Texas and California, how are you seeing these issues play out for clients right now in real time? What are you guys seeing?
So generally what I've seen isn't so much a lack of planning as much as it is outdated planning, that families have the documents, they have trust, they have wills, but those documents were drafted assuming that they were going to stay in the same place. And that opens it up to double taxation risks, probate in more than one jurisdiction, and estate plans that, unintentionally break down when the residency changes. So that's what we've seen in our practice.
Craig, how about
Yeah,
yourself?
to follow up on that, I mean, you mentioned that poorly structured estate plans can create as much havoc as
Or
no
if
estate
not
plans.
more,
I actually think
maybe.
it can be much more. I mean, it depends on your definition of poorly, but at least when there's nothing there, there's no arguments about intent. There's no arguments about, these things conflict with each other. It at least that part's clear. And when you see a really terribly executed estate plan, or one that, as Marlon mentioned, is quite outdated, it can cause all kinds of problems, including litigation and fights between family members as to what was actually intended, how things are supposed to proceed. It can be a bit of a disaster, and that's before you get to fun things like tax.
So here we are talking to a Canadian attorney about litigation. And Marlon, you only thought we litigated here in the US. So au contraire. Uh, I was just reading an article yesterday in the Investment Executive, which is a Canadian trade magazine for financial advisors, and they were talking about legislation in British Columbia. Here's a good one for you, estate planning story. Nothing cross-border, but just an example of the courts in British Columbia basically approving of a gentleman who was living common law with his spouse for many years, but didn't have ownership. The spouse died intestate,
Oof.
and he had no funds to buy the property that the one asset she had was some real estate, and it went to court. So the daughters, her daughters from another married, claimed that it was her property. The spouse, who had no assets, was claiming, well, it'll cause me hardship if I have no place to live. So believe it or not, the courts agreed in favor with the father, and basically they have to share ownership of the property. More or less, that's kind of the story. So, yes, they do litigate in Canada as well, Marlon, shockingly. Not
That, I mean, that arrangement sounds so pleasant.
Yeah, for sure.
the daughter didn't seem to think so. It's ironic that she was like, wait a minute, that's my place. And the judge said that basically there's a shared ownership by percentage.
hmm
So interesting. Okay. So
Probably not the last time they'll be in litigation.
oh
We're just paving the road now.
yeah. Well, the thing it is that we're not dealing with ultra high net worth people, which in a lot of cases where we sort of reside. But anyway, time will tell. Okay, we have a lot to cover here, and I think we should get right to the questions, because otherwise we could be keeping you guys here for a long time. So let's get right to the questions. And again, we're addressing the 3 questions cross-border families should ask about structuring their estate plan for mobility in 2026. So we're going to get right to it. Question number 1. We plan to live in more than one country during retirement. How should we structure our estate plan so it survives multiple jurisdictions and locations? So, Craig, we're going to start with you, and then we'll do a follow-up with Marlon. So, Craig, take it away.
Yeah. So, I mean, I think first and foremost, the biggest thing is understanding what you're signing up for, or what you have to deal with when you're dealing with assets in multiple locations and the potential for relocations to different places. I think the biggest thing, more than any particular document or particular strategy, because a lot of those can vary based on your exact scenario. The biggest thing is to set up a team, usually a financial planner, advisor type person, an accountant, and a lawyer, and then it can expand from there depending on what you're dealing with. In each location where you have significant assets or where you reside, usually those are the same thing, but not always. Having those people connected and connected to each other and established, and people that you can contact, that means that if something changes on your end in terms of a move, a new asset, some sort of life change, relationship change, or something like that, you can reach out to them as a group. They can tell you what actions need to be taken, discuss with each other, especially if you allow them to do that, rather than the really tricky thing being going to each one, getting a takeaway, then going to the next one bit by bit, and each one will then probably tell you to go back and ask the question of the other one, and then you're bouncing back and forth like a pinball. So having a team in place in each location is far and away the most important thing to do.
Yeah, I tell clients all the time not to work in silos with your advisor. We should be working as a team, not one and then the other, and then the he said, she said, and sometimes you can get contradicting points of view when you don't have everybody in the room at the same time. That can also happen.
Yeah,
you get differing opinions, where if you put them all together, they would come and see things sort of the same way in the best interest of the clients. Okay, Marlon, for U.S.-based elements, we have revocable trusts. So what foundational structures ensure portability across states or borders? And then Craig, on top of that, how does this align or differ with Canadian wills and power of attorneys for multi-jurisdictional retirees? So we'll go with Marlon first.
Sure. So if I have a US based client and they have property in 2 jurisdictions, then what I want to do is I want to make sure that their trust has language in there that allows them to change the situs of the trust depending on where their residency actually lies. I also want to make sure that their trust has homestead language that's appropriate for their homesteaded jurisdiction. So basically what we want to do is we want to ensure that we understand where their intent to reside is, and then where their other properties may be. We want to have a tax specific language for real estate properties, just so that we know if we've got a property in California, that California law is going to apply to that. If we've got a Texas property and it's homesteaded, that homestead law will apply to that. And as Craig mentioned before, we definitely want to have a tax team associated with that because California taxation is very different than it is here in Texas. And so we want to make sure that there is some synergy in their estate plan to accomplish that goal.
And it would also apply if, for example, we had a client of Craig's up in Canada that moves down to either California or Texas, as an example. You would want to be working with Craig as well across that international border for the same exact purpose. You would want to have wording in the trust documents acknowledging the existence of the Canadian property.
That is absolutely true. And we would want to make sure that, again, we were sitting down with people like Craig and ensuring that the language across documents sort of siloed out US based assets in a US based estate plan versus Canadian based assets in a Canadian based estate plan, because the two should not govern each other. There should be no overlap. There really should be two concentric circles, essentially.
Okay.
Yeah, and I think to
Go ahead,
follow up
Craig.
on that, it is interesting because we're talking about how you don't want your advisors to be siloed, but to a certain extent, we want everything to work holistically, but with the Canada and US assets and everything to be completely siloed as best as they can.
Right.
Yeah.
You cannot put Canadian, like one of the things we hear all the time down here in the US and Maryland, I'm sure you as well, you cannot put Canadian assets in a US revocable family trust, for example. Would be a perfect. And also on top of that, if you don't mind adding on that, you do not want to have a Canadian resident acting as a trustee of a state either. That's another.
That is correct. In fact, if you have a non-US person at the helm of a US trust, the US tax code is going to treat that incredibly negatively. It gets taxed much more harshly. And so you really want to avoid that. If you are a Canadian moving to the US, just make sure that, again, you have a US person at the helm of your US based trust. That's the best advice I can give you.
Yeah, and when we do that, sometimes what we have to do, I know we do this in California, and also I got clients in Texas where I've done this, where we've actually brought in a quote unquote fiduciary
Mhm.
to act as the successor trustee, just so that we don't have the risk of or the issue of bringing in a Canadian on that, because that, like you said, it turns it into a major tax problem. And Craig, does it apply the same in Canada with where a Canadian maybe coming or American moving to Canada wants to have a family member or friend in the U.S. acting as a executor of a will in Canada? Do you tell them to avoid it for the same reasons?
Yeah, and it causes tax problems, whether or not it actually causes increased taxation. The extra hoops of jumping through having a non-resident estate, or because wherever the care and control of the estate, so wherever the executor generally lives, that's where it is deemed to be resident. That causes all kinds of additional filings and extra things that have to be done, and they have to be really carefully planned for if you're going to do it. Typically, it's not worth it. And it also causes other steps that have to be dealt with. Different provinces have rules about non-resident executors. Some require you to put up a bond. Other ones, might say it's not allowed. It varies based on the province.
Okay, I got one for both of you here. What if you have a client that relocates frequently? Right, not just one. How do you recommend incorporating that flexibility into an estate plan, and with the intent of trying to minimize the constant need for revisions? Is that possible even?
In our case, so in the US, generally what we want to do is, again, we really want to figure out where their homestead is going to be. And unfortunately, that does mean because of the way the tax codes vary between the states, unfortunately, it does mean some revision. If they move residencies very frequently, unless there is a game plan to move back to an originally homesteaded location, they are going to be forced to make some changes to their plan from time to time, depending on the length of stay, and again, whether or not their intent is to move back.
Craig, your thoughts?
Yeah, if we're talking about moving back and forth between Canada and the US, sometimes there isn't a huge, just strictly on how the will is worded, there isn't necessarily a huge change because we're limiting it to the Canadian assets being dealt with a particular way with particular Canadian executors, regardless of where that person is residing. If the person is moving between provinces, it can be a bit of a different story because you're typically looking for executors that are resident in the province that you're speaking of and where you're located. So you might have to do some changes there. hopefully it's sort of managing between two different options and bouncing back and forth a bit if it's a frequent change between provinces.
So again, the planning aspect of this is to get out in front of it, quite frankly, and make sure that in this case, say we have a client that's doing that move from Alberta or BC to Texas
Mhm.
and maybe California for all we know. Get out in front of it, get your team in place, tell them what you're planning on doing so that they can get the documents structured as efficiently as they can. Right? That's clearly the plan here. This is not one of those, oh, by the way, yeah,
No.
we
There's
did
no,
that. Yeah,
it
that's
should be
always
more than a sticky note to your lawyer. Yes.
well noted. Our topic today is the three questions cross-border families should ask about structuring their estate plan for mobility in 2026. And joining us from Brenham, Texas, is Marilyn Schultz, a Texas estate planning attorney who also is licensed in California. And from Calgary, Alberta, is Craig Trevett. He is a founder of The Last Word, and his law firm assists clients in crafting comprehensive wills and estate plans. And he's licensed and works with clients in Alberta and British Columbia. So, guys, let's move on to question number 2. Um, my husband and I are Canadian citizens currently living in California. We are not sure how much longer we'll remain in the US. Is it possible to protect our estate plan from tax law changes in the US and Canada over the next decade? And I've been waiting for Marlon's response on this because I was waiting for the cackles of laughter here, but I want to hand this over to Marlon first, and then we'll give Craig a chance to chime in. Marlon, take it away.
So first, I think it's important to note that there's no way that we can freeze the tax law. I think even Canadian citizens, Craig, I'm sure you can attest to this, that tax codes are frequently rewritten every year, sometimes in pencil, and usually by people who have never practiced law. And so sometimes the arrangements that we get in terms of the tax code can vary very widely from year to year and from iteration to iteration. And so what we're not trying to do is freeze the tax code, but we are trying to build structures that are resilient. And so really what we're going to try and do is we are going to use, flexible marital and bypass, planning in terms of our revocable trusts. We're going to consider lifetime gifting strategies between spouses if we're really that concerned about how the tax code is going to change. And again, I can't stress this enough, Craig said it beautifully. You've got to coordinate with your Canadian advisors. You've got to do that to manage any kind of deemed disposition exposure. We and on the U.S. side of things are not going to know about that. You've really got to put that team together so that we can coordinate, essentially.
Craig, from a Canadian perspective, what strategy would you suggest that could possibly shield against future capital gains in this type of a scenario? Is there one that you can think of, or are we too far into the weeds here for that?
Well, there's things that you can do that, based on current rules, can definitely protect against future capital gains. There's things like an estate freeze and steps that can be taken. When we're talking about future capital gains, especially in relation to changes, I fully agree with Marlon. Like when, most Canadians know that, changes to the tax code don't tend to include a lot of grandfathering. Over the past 10 years, we've had changes to the way that testamentary trusts are taxed, going from, graduated rates, so taxed the way you are as an individual, to getting, the first dollar of income into a testamentary trust is at the highest marginal rate. So a huge difference of, nearly 50%. And that wasn't grandfathered at all. It was just, it was, people were told it's coming into effect, and a couple of years later, there it was. Affected whether it was an estate from years and years ago, the trust that's been in place for 30 years, or something that, it hasn't yet, the person hasn't passed away yet. So similarly, just a couple of years ago, to Marlon's point about things being written in pencil, just a year ago, we had the whole scenario of the capital gains inclusion rate in Canada was going to go from 50% to 66. There was a whole, a lot of people were very concerned about that happening, and it looked like it was about to happen. I know a lot of accountants who advised their clients to realize capital gains before that came into effect, to be proactive about it, which is generally a good move, but then it didn't end up happening.
Yeah.
But the toothpaste was out of the tube and they couldn't then, unrealize the capital gains. And so, the best you can do is realize that this is constantly shifting. Obviously, international agreements are maybe a bit more precarious than usual right now. And that sort of brings international taxation, agreements sort of into question as well. So I think the best thing is to keep speaking with your advisors and get the best individual advice you can, without finding a particular or pointing at a particular structure. I think that's the best thing I can suggest.
I'm going to ask Marlon this before we move on. In the U.S., there are revocable family trusts, but then there are irrevocable trusts.
That's right.
And I got to ask, just because if I don't, I'll kick myself, can you possibly, or is it ever advisable in this scenario to start utilizing an irrevocable trust, which obviously just by the term means once you put it in place, it's kind of there. Do you ever see a place for an irrevocable trust in one of these scenarios?
It depends on the kinds of assets that we're looking to manage with the use of an irrevocable trust. So, for example, I have a client of mine who she has dual citizenship with the U.S. and Singapore. And one of the ideas that we've used and floated with her is the idea of a qualified personal residence trust, which is an irrevocable trust that you would donate or sell your personal residence to for basically a term of years. You freeze that value in your estate based on the date that this is given over to the trust, and that is what's included in your gross estate. And so that is a way to use an irrevocable trust to sort of manage what kind of taxation you may have in the future. So there are definitely solutions out there for dual citizenship, and that is something that we use all the time. So absolutely, those tools are definitely in the toolbox.
Just before I move on to the next question, I wanted to also point out that when a family is planning to relocate either directly, either direction, either from Canada, United States, or vice versa, something else they have to look at, believe it or not, is in their investment accounts, they need to think about foreign exchange, something that people don't even think about, but that can have a big consequence as well. So if you're a Canadian who wants to relocate to the US, because they don't know how to manage this discrepancy between the US and Canadian dollar, oftentimes they will make ownership decisions that work against them in the future. They'll leave assets in Canada that become subject to unnecessary and unwanted taxation. So just on a note, when you're dealing with assets, it's not just a matter of, do I bring assets with me to the United States when I move here? But you have to think about foreign exchange because you're living between two countries that have two different currencies, or at least for now. We'll say for the foreseeable future, actually. So I just wanted to bring that up. So let's move on to question number 3, and this gets into the global mobility question here. So here's the question. By definition, or so I've heard, our family is considered globally mobile, even though we're only relocated from Alberta to Texas as a result of my company sending me to the US. What mistakes do global mobile families make when they assume their estate plan is done? Global mobile family. Marlon, I'll give you the first shot at this one.
Well, I mean, regardless of whether you are globally mobile or not, I think the concept or the thought that an estate plan is like a crock pot that you can just set and forget is always a bad idea. I have a really hard time with that in general. But I think, first, beneficiary designations, they always need to be updated. You need to be revisiting this all the time. You need to remember that, again, you should have a team in place of Canadian and U.S. advisors that can advise you on what assets you have, how they're growing, how they need to be positioned in order to, benefit you depending on the law. But I mean, community property rules change when you cross state and national borders. That's something that you need to keep in mind. Real estate in another jurisdiction can trigger probate. So again, you really do need to have this team in place. You really do need to go through your assets and sort of, discern, as of present day, how does this affect me if I'm moving from one jurisdiction to another, one country to another? But I mean, an update to or a failure to update beneficiaries on an IRA is that's regardless of where you live, that should be done on a pretty frequent basis. So.
Right. And also in Canada, Marlon, we have, registered retirement savings plans. We have
Right.
registered, retirement income funds. There's other iterations. There are LIRAs, LIRAs, there are LIFs, these type of retirement accounts where there are beneficiary designations as well. And again, same thing, just like you mentioned in the US, same thing applies in Canada. Need to review those beneficiaries and make sure that they're current and as desired. And it's amazing how many times you find out that people don't have beneficiaries on their retirement accounts. It's kind of amazing.
Or I'll have a discussion with someone where, something like an RSP or a RIF or these retirement savings plans that have specific rollovers for spouses. And then, oh, well, I thought I'd give this one to the kids. And then it's like, well, you're going to pay half of it in taxes if you do that.
Exactly
Maybe
right.
don't want to do that. So, yeah.
So, yeah, I think that's one of the biggest issues that you have to deal with when you're dealing with Canadians is that when they're moving to the US is just making sure. Another thing is depending on what state they want to move to. So for example, I'm going to use California as the reference point.
Sure.
Because it's a little unique there because the state of California views RRSPs differently than pretty much every other state in the country. I think maybe Georgia's the only one. It's a taxable asset. It's like a non-registered account, Craig, in the eyes of the state of California. Not surprisingly, that they're looking for some extra tax dollars. And so one of the things that we talk to clients about if they're moving from Canada to the United States and why it's important to plan in advance is that you want to adjust the cost basis just before you change your residency so that once you move to, you haven't accumulated a whole bunch of taxable gains in the plan. So you want to start like basically with a current cost base, not an old cost base, once you become a resident of California. So that's another example on top of the currency matter, which again, one of the great things here at One Capital is that, for example, my RSP account, my wife's RSP accounts, we years ago got rid of currency risk. We were able to manage a Canadian retirement account in US dollars, right? So unique thing about us, we can also manage Canadian dollars here in the US, which is another, again, matter of foreign exchange, but that's just examples. So again, the issue of beneficiaries, can you think of any other scenarios or things that we should be thinking about along that line, Craig, for clients that are making a relocation either to or from Canada?
The other thing, obviously doesn't apply to everyone, but something that really can make a big difference in estate planning is keeping in mind that the rules around matrimonial property can vary significantly in different jurisdictions. And so you might say, well, I have a prenuptial agreement that says that this is what has to occur. That may or may not be valid in the new location that you're in. And the way that you structured your estate plan to provide for your spouse, maybe in a blended family situation where you're giving some to a new spouse, some to the kids, is that going to hold up in a new location where the rules around what you have to or maybe don't have to provide to that spouse or to kids, etc., it is really important to make sure you're not offside. Otherwise, the whole thing can get overturned in court anyways.
Okay, so that leads to another question. Just thought of this one right now, Marlon. So you're licensed as an estate planning attorney in Texas and in California. As I understand it, the laws on in those states are different from each other when it comes to property ownership. So if a client just told you they were deciding between moving to California or Texas, you would probably give them a different strategy or different advice on community property depending on what state they were going to move to.
Sure. So, the interesting thing about Texas and California is that they were both at one point in time property of Mexico. And so Mexico, being a Spanish colony, actually has community property law that's actually pretty congruent from state to state. And even in their laws of intestacy, things will pass pretty predictably from one state to the other. But the advice that I give to my California versus Texas clients is this: if you intend to do nothing with your estate plan, if you decided that, signing a will is, asking for death to befall you, then do yourself a favor and die in Texas because the probate system here is much easier to deal with than it is in California. I can't ring that bell enough, frankly. And so when I have clients that have cross-border issues in terms of that, if there is a probate that needs to happen, we do our best to make sure that it happens here versus in California for that reason alone.
So if a client of mine came to you and said, or came to me and said, Wayne, I'm not sure if I'm going to move to Texas or California, and I sent them to Marlin, you would be leaning towards, probably from an estate planning perspective, you would say, well, aside from no state tax,
Yeah.
right?
I mean, that's it. I mean,
Yes.
we don't have a state income tax here. Our probate system is much easier to deal with. If you can not faint the first time you get a property tax bill, then I think you're actually in the clear. But that's really our one hang up. But for the most part, Texas is a much friendlier avenue, I think, for people that are looking to immigrate to the U.S. It's easier on the wallet.
And this comes from a former resident of California, I will
That
note.
is correct. I'm sure all of
Just
my
want to
friends
make
back home in
that.
California are just cringing that I'm saying this.
No, no. Well, I'm standing here as we speak, clearly in California territory, and I am being constantly reminded, whether I visit my friends in Dallas
Mhm.
or my friends in Florida. I have clients obviously in both states, and this conversation is brought up more than once, as you can imagine. So just on this follow-up of the for plans that people think are done,
Mhm.
what red flags do you think really need or signal that an update is needed? And I know we talked earlier about marital status or new residency, but is there anything that really, when somebody says to you, I think we're done, like in above and beyond what we've already discussed, is there any other sort of outliers that raise a Spockian eyebrow? And either of you can chime in on that.
I
I'll let
think
you go first.
okay, yeah. I mean, in general, if someone thinks that they're done, it may not be a red flag for right now, but obviously, as per our previous conversation, that in of itself is a bit of a red flag. Um, with that said, I think you'd be surprised how often I hear someone say, "Oh yeah, this is all sorted out, and we've dealt with, all of the assets." And then they casually mention that actually their company that they identified as a Canadian company, well, actually, it's a U.S. company, but and then that becomes a big issue, or vice versa. And so, obviously, if you have a corporation, making sure that it is set up the right way to, and it's dealt with in the right jurisdiction is immensely important. It's very obvious to me, but obviously, it's something that people sometimes overlook when it's their own private stuff and they're not in this world day to day.
Yeah, I agree with that. Jumping onto that, anytime, and we always think about this from the perspective of life events in our firm, that if you've got a change in a residency or a change in citizenship, or there's a marriage or divorce, or somebody has acquired foreign property, or you've had a significant increase in net worth, it's time. It's time to review those documents. And again, as we keep chiming in on, you've got to get that team together. You've got to circle the wagons and make sure that your team members are all communicating about your assets and how you're going to manage them. Cross-border issues come up a lot more frequently than people think. One of the most beautiful things I hear my clients say is, "Oh, well, it's just so simple." I love that word. I think every litigator in the country hears the word simple and they salivate because they know that means billable. So every time somebody says simple, trust me, it's not going to be that simple. Just talk to your team, figure out what's going on. Maybe it is nothing, but at least get a stamp that says this is nothing and we can move on. But again, it's really important to get that team together. Otherwise, you just don't know. You just don't know.
Yeah, ignorance is bliss and the mother of adventure, right? So based on what we've talked about today, and either one can chime in first. What is one essential step that a cross-border family could take right now to make their estate plan more mobile and resilient? We're talking about 2026 here. Marlon, I'll let you go first.
Sure. So I think that, the one essential step that I can say is that we need to stop thinking about this in terms of just straight documents and think about this in terms of structure. And again, your team is going to help you build that structure to make sure that it is more resilient. Again, we can't freeze the tax code. We can't, prognosticate the future. There's no way to know what's going to happen. But the moment that you bring your team together and the moment that they're able to advise you on what the most logical next steps are going to be for all of your assets, all of your holdings, your residency and your citizenship requirements, like this opens up the door for it to be more resilient. You're again getting out ahead of it. But I think I guess that's really the best advice. That would be the step is putting your team together, that structure.
And I think to follow up on that, just the idea of like going back to that idea that estate planning is something that people think of as being its own little thing that you deal with and hopefully don't have to deal with again. Your team is probably that same team is involved. Your accountant doesn't have to just be your estate planning accountant. There's a lot of things that if you're moving back and forth between countries, hopefully you're dealing with frequently, how's this going to affect the way my income is taxed? How's this going, my investments, all those kinds of things on a more year to year, month to month basis. Just build the estate planning part into that team, like to the extent possible. That way it doesn't feel as much like I did the estate planning, it's done. It's like thinking that you did your, financial planning once and you never have to deal with it again. It is
Yeah,
ongoing.
right.
And it changes.
Hello on that one. Um, Craig, just to sort of continue on that note, in your own personal law practice, what's a success story that you've seen where that proactive structuring made all the difference for a relocation? Could you cite an example of that for us?
Yeah, for sure. I mean, for example, we've dealt with things in the past where, for example, maybe years ago, I assisted a husband and a wife. The husband was a U.S. citizen, and the wife was a Canadian citizen. They lived in Calgary, had kids, a mix of assets in both locations, a home in Calgary and a Canadian company, various registered plans, a U.S. condo. And then when they decided to relocate back, we helped proactively, with a U.S. lawyer as well, coordinate how to manage the various assets. We set things up with Canadian wills that were tailored to the Canadian assets. The U.S. lawyer set up revocable trusts and pour-over wills for the U.S. assets, incapacity documents for both locations. And then everything was sort of lined up, fairly simply. I mean, I know we were talking about simple, but it doesn't have to be incredibly complicated. But at the same time, everything was put in place properly. And the husband did pass away. We had dealt with the situation a couple of years ago. And because everything was properly structured, there was no delays in accessing funds in the US. Each estate was dealt with separately. Everything just sort of clicked together. And despite the complexity of the scenario of these multiple assets, it was fairly smooth. Obviously, there's always something, but at the same time, it went surprisingly well, and there wasn't additional, paperwork and fights and, more tax filings than needed to occur.
Earlier today, a client call with a couple, actually a cross-border couple that lives in Ontario, Canada, and we're doing some estate planning, and in their case, there's a need for some life insurance, and it's more complicated because of the fact there's some U.S. citizenship involved. So we're looking at U.S. policies seeming to be a better fit. We talked about the need for an ILET, for the U.S. policy because it would add to the value of the estate otherwise. Lots of examples of collaboration. Marlon, I want to give you a chance just to chime in if you had an example of a case that you've been working on that would kind of fall into the same theme that you'd like to share with us.
Sure. So I had a Canadian couple that had moved to Houston, and their original Texas estate planning attorney had drafted up a will that contained a testamentary trust and placed my client's Canadian citizen son at the helm of that trust. And as I mentioned before at the beginning of this, if you have a U.S. or a non-U.S. person at the helm of a U.S. trust, the taxation on that is very brutal. And this attorney just did not know enough to know that that was going to be problematic. And so what we've done is we've redrafted their revocable living trust documents, taken them out of a will-based estate plan altogether, and made sure that there was a U.S. person at the helm of their U.S.-based trust. So we're eliminating a lot of that tax exposure as a result of that. So again, it's just making sure that you have the right people on your team that understand the consequences of international tax.
Well, we've covered a lot here, and this was we were talking about the idea of having all three of us on the podcast together, and I think it's kind of worked out pretty good here. I'm really glad you guys made time for this. I always ask this, and people listen to the podcast, they know it, but I want to ask definitely for today, because I know there are going to be people listening to this or watching this, and you'd be surprised or not. But the question is, how do they get a hold of you? Okay, so Marlon, for example, if someone's listening and saying, you know what, I got property in the United States, I moved back to Canada, I'm wondering what if I did this right. How do they get a hold of you?
Sure. So they can always contact us at the main line at the office here, and that's 281-529-5176, or they can contact me at www.brenhamaestateplans.com.
Perfect. And Craig, how about yourself? How can people contact you?
Yeah, I mean, our main office line is 403-805-2921. But the easiest way is just reaching out via our website, which is the last word, so THELASTWORD.ca.
Perfect. Well, Marlon, thank you so much for joining us today. You're a great guest as always. Looking forward to seeing you in the not too distant future. Marlon Schultz is a Texas estate planning attorney who's also licensed in the state of California, and she specializes in helping clients navigate complex relocations and estate planning strategies and asset protection. And Craig, thank you again. Great seeing you, and I really appreciate your collaboration with us today. Craig Trevita is the founder of The Last Word. His law firm assists clients in crafting comprehensive wills and estate plans. Marlon, Craig, thank you so much for today, and great that you made time for us. I really appreciate it.
Thanks, you.
Wayne.
I look forward to bringing you the Three Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification when our latest episode has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.